Yes.
My lords, my lady, I appear for the appellant, along with Oscar Johnson, King's Counsel, Peter Burgess, Audley Hannah, and Denise Newton-Briggs. And my learned friend, Crystal Royal, King's Counsel, appears for the respondent, along with Darren Cash. Now, I propose in a moment, by way of opening, to take the board briefly to some aspects of the pleadings and to some of the evidence which is important for our grounds of appeal. And then I propose to address the board in submissions that are structured in line with our written case. So starting what we've called the migration issue, namely the issue as to whether the 2012/2013 leak impacted the property. Secondly, the Rylands and Fletcher issues. Thirdly, the area that we've identified as being whether Rylands and Fletcher is academic, because learned friend takes the point that the judge, it is said, found Rubis liable on the footing of trespass, nuisance, and negligence as well. And fourthly, on the point as to damages, our point that the Court of Appeal made an impermissible leap in deciding that it could attribute any loss and damage to the 2012 leak. It's possible that a third of those grounds belongs more in a reply. So depending on how I do in terms of timing, I might defer it to that stage. Now, before going to the pleadings, I just wanted to make or to identify four overarching points, to identify some important themes which I'll seek to develop in looking at the documents. Firstly, it's important to bear in mind that the respondent's case at trial and in the Court of Appeal was that the 1994 leak had caused the property to become contaminated, and that due to a culpable absence of any remediation by Texaco and then Rubis, the property remained in a contaminated state at the time of the 2012 leak. That's how I'll refer to the second leak. It's been referred to as the 2012/2013 leak in the documents, but I'll just call it the 2012 leak. So the respondent's case was that it remained in a contaminated state at the time of the 2012 leak and indeed at the time of the trial. Secondly, that although the first instance judgment is not a model of clarity, it's apparent that the judge accepted that case and accepted those contentions. Thirdly, the respondent's contamination expert, Mr. Bowleg, gave evidence of low, we say extremely low, levels of certain hydrocarbon substances present in the monitoring well on the property in a sample taken in 2014. He said, without giving any reasons, that the suspected source of this was the service station site, but he did not give evidence, we say, as to whether, in his opinion, this was due to the 1994 leak or the 2012 leak, or both. And finally, and relatedly, the judge did not make any findings as to the extent of contamination caused by each leak or the extent of any loss and damage caused by each leak. And nor could he, as there was no evidence before him going to that.
Do you use the extent of, as it were, deliberately, by accepting sub silentio that reading the judgment as a whole, he found that there was some migration, 2012-13?
Well, my lord, we say that he didn't find that there was some migration. We'll come to this, but the way the judge seems to have approached the migration issue before him was that he accepted my learned friend's submissions that because in cross-examination certain questions hadn't been asked of Mr. Bowleg, as it were, the judge was constrained to accept that there had been contamination in 2012, that essentially the point had been conceded on the footing of the rule in Brown and Dunn by the lack of relevant cross-examination. My Lord, just for a moment to foreshadow what we say about that, we say that's wrong for a number of reasons, but very broadly. Firstly, Mr. Bowleg had not said that, in his opinion, the 2012 leak caused any contamination. And we'll see in a moment when we look at the detail of the case, that for various reasons, and this was really the case advanced by my learned friend below, the 1994 leak looked like the more likely contender because of the relevant geography. But Mr. Bowleg didn't say that the 2012 leak, in his opinion, caused contamination.
You made that point, that was your third point.
My Lord, it was, yes. And so we say the judge didn't make a finding, if I can put it that way. The judge seems to have accepted the submission that the issue was closed to him because of a concession said to flow from the absence of relevant cross-examination of Mr. Bowleg. So, my Lord, when I make my fourth observation, that's why I say, as we're taking the judge's approach for a moment as read, if we get this far, it's also relevant. The judge didn't make any findings as to the extent of contamination or loss and damage attributable to each leak.
At some stage in your submissions, you'll need to work in something about Davy and Roy and points not being taken in the Court of Appeal. I'm no doubt you have it in mind, but we're content to leave it to you where you work those in. And why, if it be the case that Davy and Roy prima facie applies, this is an exceptional case, if you say it is.
My Lord, yes. I will indeed come to those points. Can I then take the board briefly to some relevant aspects of the pleadings, having set the scene in that way? Starting, if I may, with the statement of claim. The document commences at page 16. And if I can pick it up at page 17 after some introductory paragraphs. Paragraphs 8 to 10, the board sees it's pleaded that the maintenance of fuel tanks and pipes or storing petroleum products constituted a non-natural use or user of the service station site. And that's paragraph 10.
Yeah.
Then page 18, the document moves on to the ownership and occupation of the service station site. We just note paragraphs 13 to 16 set the scene for the claim against Rubis in relation to the 1994 leak. In paragraph 16, the board contends that when Rubis acquired the long leasehold interest in the site, it somehow succeeded to Texaco's liabilities, a contention that the Court of Appeal rightly rejected. Paragraph 17 moves on to the lease, and I'll come to that as a separate document. Then picking it up again, please, at page 20, paragraph 24. Here, the document moves on to the 1994 release, or the 1994 leak, and the fact of the leak is pleaded at paragraph 24. And then again, if we can take it through, please, to page 22, paragraphs 30 to 32. The board sees there it's pleaded that Texaco did not remediate the contamination at the plaintiff's property at all following the 1994 leak. And then paragraph 35, also commencing on page 22, leads the 2012/2013 leak. And skipping through to page 24, just to show you pleading at paragraph 42, 41, 42 of the claims in negligence. 41, 42 premised on Texaco's failure to remediate the 1994 release. And we'll see in due course that the claim essentially was said to result from some sort of continuing duty to remediate following the leak. And it was said that Rubis had either succeeded in Texaco's liabilities or had become itself subject to this duty once it acquired the land. And just looking at page 25, towards the bottom of the long continuation of the particulars, which take up most of this page, the board sees an example of the point that I made earlier. It said, for example, that despite Texaco's knowledge of the 1994 release and of the continuing duty to remediate, it failed to do so, and such failure and or omission and or neglect continued from the date of their knowledge of the release up to the date of the 2012/2013 release and continuing. Then over the page 26, paragraph 43, it was said that by reason of the matters pleaded above, essentially Rubis's acquisition of the long leasehold interest, Rubis was liable for the omissions of Texaco. Then to note paragraph 44, and this is a forensic point that we'll come back to. There's reliance in this paragraph in relation to the 1994 release, to the reference to a historic release in the document called the Black and Veatch report, which I'll come to in a moment. But the Black and Veatch report was produced for the Bahamas Environmental Authority. It was in evidence by agreement, and we say contained important evidence as to both this historic release, which appears to have been a reference to the 1994 leak as contended by the plaintiff, and which occurred, as I say, in close proximity to the property. So it contained important evidence as to that release and also as to the 2012 leak, which, as we'll see, took place from a different, or originated from a different part of the service station, and contained important evidence as to the movement of contaminants after the 2012 leak, what's been referred to as the plume, following the groundwater movements. And
that's all in the context of a negligence claim arising out of the 1994 release.
Yeah, so
what's a failure to remediate after 1994?
Well, the way the case was put, I think, against Rubis was that once the 1994 leak had occurred, Texaco became subject to a duty, common law.
Which Rubis somehow inherited.
To remediate, which Rubis somehow inherited.
Not merely the duty, but the consequences of the duty not having been complied with.
Yes.
Yeah.
Yes. And paragraph 45 is another example, and there's another one at 46, of the contention that the adverse consequences of the 1994 leak were continuing, as at the time of the supervening 2012 leak and as at the time of trial. Then, so paragraph 48 then pleads the conclusion in relation to the 1994 leak as to Rubis being liable. Then at page 27, the pleading moves on to the claim against Rubis for negligence in relation to the 2012 leak. And I show the board that, really just to take it through to page 29, the particulars of negligence. To show the board what the case was at trial in negligence against Rubis. Make good a submission that I'll make later on, which is that we don't see, nowhere do we see in the judgment the trial judge dealing with any of these particulars. This is one reason why we say, properly understood, the first instance judgment is premised on Rylands and Fletcher alone.
Well, so far as 2012.
So far as 2012 is concerned, yes. Yes. Now on page 30, paragraph 50 pleads the Rylands and Fletcher claim in relation to the 2012 leak. said that the 2012 leak resulted from the said non-natural user of the service station and failure of the defendant to prevent the escape. And paragraph 51 pleads a separate nuisance claim, and paragraph 52 pleads a claim that the 2012 leak constituted a trespass. Then again, staying on that page, page 31, paragraphs 53 and 54, one sees again the case that the 1994 leak caused inconvenience and deleterious effects which were continuing at the time.
51's about nuisance, isn't it?
51 is nuisance, yes. The 50.
Whereas the trespass in relation to the 2012?
52.
52, thank you. Yeah.
And then 53 and 54, one sees again the contention that the 1994 leak, because of the absence of any remediation, was continuing to have damaging consequences and deleterious effects at the time of the 2012 leak. And as one sees, in fact, at 54, it's said that the occurrences of the plaintiff's exposure to the discharge of noxious, offensive and toxic vapours continued after and were exacerbated by the 2012 leak.
Yeah.
Then at page 32, paragraph 59, the pleading of special damage commences. And over on page 33, one sees the items that are pleaded there, cost of testing and sampling and so on. Claim for cost of remediation at $782,000, and little 4, diminution in value of $131,000. One sees it as a matter of pleading. These heads of loss and damage were, as it were, rolled up, pleaded in a unitary way, as between the two leaks. And paragraph 60, again, please, the adverse consequences of both leaks are continuing as at the date of the pleading. Now, just briefly then moving to the defence.
This is, I hope I can summarise it, scene setting, isn't it, rather than
My Lord, this is scene setting.
Any particular point.
My Lord, it's scene setting, but it's partly scene setting in relation to the points taken against me that these are that the grounds of appeal to the Court of Appeal don't allow for the grounds that I now raise before the Privy Council, because one of our points is that in looking at the grounds of appeal to the Court of Appeal as drafted, one has to bear in mind what the issues were at trial and on the pleadings, and as it were, one interprets the grounds of appeal with that relevant knowledge. Just very briefly on the defence, just to show the board, again in that vein really. Firstly, paragraph 10, page 39. Denying paragraph 10 of the statement of claim, which had pleaded that storage of petrol in the tanks was a non-natural user. And then paragraph 15, which begins at the foot of page 39, pleads, starting right at the foot of page 39, that at all material times the fuel tanks and pipes were under the control of the third party Fiorente Management Limited, which the board will remember was Rubis's tenant and as were the operator of the service station. Then paragraph 19, last 3 lines, similar theme, averred that the maintaining of the petroleum products at the service station was controlled by Fiorente at all material times. Again, paragraph 20, the fuel tanks and pipes were under the control of Fiorente. Then skipping through, please, to paragraph 32 on page 45. Under the heading of the 2012/2013 release, defendant denies that any petroleum product escaped from the service station onto the property, as alleged or at all, and pleads that experts have permission to analyse contamination in the vicinity of the service station, and that the extent of that has been definitively determined and doesn't extend to the property. So that, as we're sets the scene for what we've called the migration issue. And then page 47.
They were only denying migration. They weren't denying that either leak took place.
My lady, that's right. And as we'll see, in relation to the 2012 leak, it was common ground at trial that there had been a leak in 2012. So the issue was whether that leak had caused any contaminants.
The report says only 20,000 gallons.
That's right, my lord, yes. The page 47, paragraph 37. Again, a plea that any discharge would have been caused solely by the acts and or defaults of Fiorente, and particulars 1 to 3 repeat the case that Fiorente was the occupier and the controller. Particular number 2, any petroleum products brought onto the service station was for the sole use and benefit of Fiorente, and the defendant wasn't engaged in the sale of petroleum products from the service station. And as we'll see in a moment when we look at the lease, that was correct. And then page 48, paragraph 39. The denial of paragraph 50 of the statement of claim, which was the Rylands and Fletcher plea. Again, traversing.
Which paragraph you want?
Paragraph 39, page 48.
Oh, sorry, right, thank you. Yeah.
And so it rounds up again those points about non-natural user and about Fiorente being the correct defendant in relation to any Rylands and Fletcher claim. Can I then move to look briefly at the Black and Veatch report, which is quite an important document. It starts at page 976, Roman 1. So when the bundle was being put together, originally the Black and Veatch report was omitted. So it's been put in, but with little Roman numbers. So it's always 976 something. So we need to do 976I to find the beginning of the document. And if I can pick it up, please, at 976.5 and 976V. paragraph 2, big heading 2, summary of release and initial response actions. The release was reported to Rubis Management on the 19th of January 2013. Also reported that the leak was thought to have begun on 25th of November 2012. The release occurred in the riser pipe between the fuel tank and dispenser number 5. The equipment was repaired on the 22nd of January. All tanks and lines passed tightness testing following the repairs. And as my Lord Briggs pointed out, variance records show that approximately 24,000 gallons of unleaded gasoline were released.
And was this all released underground?
My Lady, that appears to be the case, yes.
Yeah. It's a riser pipe, but the leak was below the surface.
And one presumes that explains or partly explains the delay in the leak being reported to Rubis. No doubt, had the leak been visible above ground, one would hope that Fiorente would have reported it much more quickly to Rubis.
Well, I might have thought 24,000 gallons would show up on the records of the difference between how much was being dispensed and how much was meant to be being put in.
Well, my Lord, absolutely, and as we'll see, the one of the obligations that the lease placed on Fiorente was, I think daily, to look at look for that type of variance, which obviously is a danger sign of something amiss, either a leak or something else.
So I would imagine 24,000 gallons of petrol takes up quite a lot of space. So are the tanks in some kind of underground chamber that then filled up with petrol, or are they just packed in the earth so that the gallons of petrol just seep out into the earth?
Well, my lady, it's a good question. What we'll see in a moment that the tanks are located in a particular corner of the site. The underground storage tanks, as they've been referred to in the documents, or USTs, are situated in a particular, the southeast corner of the site, which is the part of the site in closest proximity to the respondent's property. There then appear to be...
So it is the closest to they are stored closest to her property.
Well, that's where the tanks are.
Yeah.
But what we'll see in a moment is that there's then quite a distance between the tanks and the dispenser pumps. And we'll see that the evidence suggests that, the evidence seems clear that the 2012 leak occurred where one of the riser pipes comes up to feed the dispenser pump. So the 2012 leak occurs actually in the little sort of island where all the pumps are. But the 1994 leak appeared to be due to some problem with the tank.
But how many meters between the storage tank and the
dispenser number 5?
Number 5.
Well, we'll have a look. I'll come to the plan in a moment. Okay. It looks like a sizable distance. And there's also some relevant evidence in the Black and Veatch report to the effect that the findings made at the time of the 2012 leak suggested that there had been no migration of contaminants from the area of the dispenser pumps southeast towards the underground storage tanks. It might help if I take the board to one of the plans. There are a number of plans in evidence and exhibited to this report amongst other documents. But if we can go to 976 XXXI, or so 976 Roman 31, I can show you what...
31?
31, yes. So 976 XXXI. This is a plan at figure 16 to the Black and Veatch report, which we'll have to come back to in a moment, but just so the board gets some idea of the orientation. The block of land in the centre is where the service station is, and the board can hopefully see the words release point round the middle and a little arrow pointing to a particular point in a little sort of hatched rectangular area. So that is pointing to the particular dispenser pump where it said that the riser pipe feeding that pump was leaking and gave rise to the 2012 release. And you can see that the other dispenser pumps are located in that same area. There's a convenience store at the foot of the dispenser pumps, presumably where people go to pay as well. Then, just worth noting, because we'll see it discussed in a moment in the text of the report, to the south and to the west, some buildings belonging to Cable Bahamas. So when we see in the text reference to Cable Bahamas buildings, it'll be to one or other of those. To the north or the northeast, you can see the most northeastern, Munro. That's the Munro property, which we'll see gets a mention. Next to that, to the left, the Evans residence also gets a mention. Then next to that on the left is something called a commercial property, which we'll also see, I think, is sometimes referred to as the Edgecombe property. Now, and also a convenience store up there. Now, those properties, the evidence suggests, were all impacted by the 2012 leak, because we'll see that's where the evidence shows the groundwater plume moved in that northwards direction from the release point. And so those properties were all in the danger area. In the center of this plan, at the bottom, there's a little triangle of buildings, one of which has been annotated LR. That's the respondent's house.
Half a Robinson.
Russell, I think.
I'm sorry.
Yes. Robinson Road is the road that runs along the north boundary of the service station. And just to the left of that and slightly north, there's another little hatched area with a sort of X marks the spot, and that's where the underground storage tanks are. And we'll see in a moment.
Is that with all the circles?
If my lady has the house with the LR handwritten in, just northwest of that,
I see.
a little hatched area with an X. It looks like it's right at the southeast boundary.
Just across Grace Avenue, basically.
Yes, exactly. And that's where if one were able to, as it were, zoom in well enough, one would see that's where the USTs are. That's underground storage tanks. So I'll come in a moment to what the evidence says, but what appears to be the case, and what was the respondent's case at trial, was that the 1994 leak was in the region of that X. It came from some sort of leak in an actual tank. Whereas the 2012 leak came from the release point that we see marked up here. Now, my lady, in answer to my lady's question, I'm not sure that we have a scale on this plan, so I can't help you with how many meters there are in between, but
That's quite important.
Mr. Burgess tells me it's. Oh, actually, there is a scale. I'm sorry. Just under the compass, over on the right-hand side of the plan, there's a line denoting, I think, 60 feet. So.
I can't see that. I'm sorry.
Oh, I can see the scale.
The bottom right corner next to the writing.
Corner, yes.
Graphic
Oh,
scale,
yes.
but what it actually says is difficult to...
So you think that 60 feet is about, is that distance?
It looks as though, I think there's a little apostrophe at the end of the 60, so that's foot. So 60 feet.
Yeah.
If that's right, then that would suggest that, give or take, the distance from the release point to the southeast corner of the property, or the UST area, is something less than 100 feet, but in excess of 60 feet.
Oh, from the release point. Oh, it may be 100.
Yes,
Probably about
120
or something.
Yeah, no, so I was looking at the tanks.
Yeah.
Yes.
Even 180.
Between the what?
tank.
The tank?
Oh, well, or
release
LR, you mean? Do you in the release point?
No, LR is her house.
Yes.
Between the release
I
point
don't know what
and LR.
Yeah, is what we're
Is what we're talking about.
Sorry?
How far to her house from the
Between
release
release point
Yeah.
and LR.
Yeah.
Yes, that looks like a good 180 feet or so,
Yeah.
and something less than that between the release point and the tanks, but still probably a good 100 feet or so perhaps from the release point to the tanks. Now, just coming back then to the body of the, we'll come back to figure 16 in a moment for some data that it contains, but coming back to the body of the report, if I can, at 976 Roman 7. Firstly, under the main paragraph 3, the main heading, Summary of Environmental Impacts. As a result of the investigations conducted by Rubis, environmental impacts to soil, groundwater and indoor air were found on the site, that is the service station site, adjacent CBL properties, Cable Bahamas properties, and commercial and residential properties on the north side of Robinson Road. Both business and residential populations were impacted by the release, including evacuation of the CSR building, etc., and sheen on private well water from residential properties north of the site. And then 3.1, extent of free product. Free product, I think, is referring to actual gasoline, as one sees from the words in parentheses in the first line there. Based on the information presented in one of the documents, based on gasoline was initially present in private wells.
Sorry, CAR is short for what?
It's another report, my lord. I think it'll be referenced at
All right. So anyway, it's a report, is it?
contamination assessment report.
Okay, thank you.
So free product was initially present in private wells on residential properties on the north side of Robinson Road, within the site boundary to the east. To the south in wells along the CBL/Rubis property line, and the west.
Not, you say, the southeast. That's the road.
Not the southeast. Then 3.2, extent of impacted.
But sorry, what is the CBL Rubis property line?
So, my lord, going back to figure 16 at 976.
We've also got a copy of it, I think, annexed to the statement of facts and issues in our
I'm grateful, my lord.
at the end of the statement of facts and issues.
3598, perhaps?
Yes, 3598.
Oh, yes.
Yes.
Yeah, that's...
With that property line, CSL, yes, that's the one that,
It's CBL Rubis property
at the beginning.
So
to the south in well.
And all it's very small print, but the wells are all identified with a dot and a number, aren't they?
my lord, they are. I'll come to that in a moment. And the well on the respondent's property is MW47.
Gosh, I can't read that.
But yeah, so and obviously the Rubis property obviously is the service station site.
Yeah.
M47.
MW47, my lady, was the code given to the monitoring well on the respondent's property.
No. Does that show on this map, or are you just...
There's an arrow that points to it. If you look at the bottom
Oh, yes.
of the
Oh,
map.
yes. I see.
So that's her water well from which she used to draw water.
I believe, my lady, that her
It's
water
not.
well, the use of which was discontinued after 1994, at some point was converted into a monitoring well. I think that's right.
So MW stands for monitoring well. doesn't it?
MW stands for monitoring well. But certainly her case was that following the 1994 leak, she had to stop using her well and started using town water instead. That's MW47, which we'll come to what the evidence said about the findings made on examination of MW.
But just the to the south in Wales along the CBL Rubis property line, I think the CBL Rubis property line is looking at the Cable Bahamas building to the south, isn't it? And then were you telling us that these dots, they're quite small on this map, but are those monitoring wells or wells? What?
My lord, I believe they are.
Okay.
If we're looking at 3598, there are various different versions of these documents, but we can see from the bottom right-hand corner that this deals with the inferred extent of dissolved benzene, and it's March 2014. So I'll come back to it, but one can see that there are 3 concentric zones showing this inferred extent of dissolved benzene. And what I think has happened is that the outermost line, which is the lowest concentration, you can see that from the very top. If you look at the outermost, not circular, but sort of semicircular ring, one can see that that's 1.0 parts per billion.
I'm so sorry, where are you getting that from?
If my lord's looking at 3598, you can see that
Right up at the top, but beneath the 2 of Annex 2, if you go downwards from there, I think.
yes,
Right.
And if you've got very good eyesight, you can see 1.0 ppb.
Yes, in fact, it's very slightly clearer on 97631. Yes, I see.
Yes.
So these are the concentrations indicated for those lines.
exactly, my lord. Yeah. So the next one in is 1,000 parts per billion,
Yep.
and the central one, closest to the release point, but north and northeast of that, is 10,000 parts per billion. And the outermost one, 1 part per billion. What appears to have happened is that the inferred extent line of that one has been drawn by where there is, you have a well which has some detectable level, and then the next well out in the relevant direction has got not detected, then the line of the inferred extent is placed between those 2 wells. And I'll come back to this, but we'll see that this document at least shows, the Black and Veatch report shows MW47, the respondent's well, as not detected.
Yes, 3598 isn't actually a copy of page 97631. There's more information on page 3598.
There is, my lord, yes.
But the long and short of all this is that this report suggested, if it's correct, that there wasn't any escape, any migration,
Yes.
using migration in the sense that we are doing it.
Yes.
Yeah.
Oh, that's right. And I'll take the rest of it reasonably speedily, because I think I've more or less shown the board the crucial documents. But just going back for a moment to 976 Roman 7, extent of impacted soil. The board sees that said that based on initial findings from the interim remedial action and samples associated with the UST and piping removal in August 2013, a supplemental soil assessment was conducted to delineate the horizontal and vertical extent of impacted soil. And then the second paragraph, the investigation began near the source of contamination, the fuel dispenser island, and proceeded outward in approximate 30-foot grid intervals to determine the horizontal extent, and showed that impacts to soil and the highest contaminant concentrations were in the general area of the release. No evidence was observed that impacts from the release extended southeast along UST lines towards the UST pit, i.e. away from the dispensers. That's the point I made to my lady a moment ago, that when looking at soil contamination, no evidence was observed that there was any movement of contaminants from the fuel dispenser island in the southeast direction down towards that little area where X marked.
Doesn't quite answer my question. I mean, it says they managed to recover 7,173 gallons, 24,000 were released, and are they released into what?
Well, I think the 24,000 that was released in the leak, one infers from the documents, must have been leaking from the riser pipe into the soil immediately surrounding the riser pipe, and then into the ground from there. So we certainly see that there's suggestions in this document that it will get into the groundwater, and it will contaminate the groundwater in certain areas. And then we'll see some evidence in a moment that the groundwater, obviously the groundwater doesn't remain static, it moves. And the evidence was that the groundwater plumes move to the north from the release point. But the fuel must have been running, my lady, if I can put it colloquially, into the ground, where the dispenser...
So you've got thousands of gallons of petrol seeping into the soil.
My lady, yes. Yes.
And just on what's on page 9767, I'm not sure I fully understand it, because looking at page 3598, the outer ring does seem to cover the UST pit.
My lord, it does. That's...
I mean, admittedly at a lower concentration, but it seems to show that something has happened there.
Yes, I think the difference is that 3.2 is dealing with soil contamination. 3598 is dealing with what we're going to come to now, I think, which is groundwater. So the report, one of the slight problems is that none of this was really explored in any detail at trial. But this report suggests that, as it were, when you're investigating these things, you'll take soil samples looking for soil contamination. Separately, you'll look in these monitoring wells or groundwater contamination. And I believe that 3598 is based on readings taken from the monitoring wells. So looking at groundwater. So my lord,
Right.
we see the relevant part of the report for that at 976 Roman 8.
So 3598, those parts per billion zones that you were describing, they're not a graphic representation of what you were showing us at 9767, because 976 Roman 7 is dealing with soil contamination and 3598 is dealing with groundwater. Is that right?
I think that's right, yes. The 3.2 refers to figure 8. What I was showing my lady was figure 16, which is similar to 3598. I don't think that figure 8
Sorry, where are we?
is so helpful. Figure 8 is 976.26. So that figure 8 is the diagram which is referred to under impacted soil. So that doesn't have the same zone markings, but that tells us, figure 8 tells us where soil samples were taken from.
Sorry, where did you say figure 8 is?
It's at 976.26, Roman 26. And so what figure 8 shows us is the locations of the taking of samples for checking for soil contamination. And we can see that a number of samples were taken around the underground storage tank areas, but the conclusion was that so far as soil contamination is concerned, there was no evidence of soil contamination spreading in that direction down to...
But this wasn't, as you say, this wasn't explored at trial, because how her evidence was in the witness box with somebody else giving the same evidence, there's this horrible smell of petrol in my house the whole time. And that's what the judge accepted. So where do you say the horrible smell of petrol, which the judge seems to have accepted her as a credible witness, where do you think the horrible smell came from then?
Well, my lady, On the judge's findings, there was contamination in 1994. This report's also relevant to that, my lady, so I'll come to that. That contamination was never remediated and continued to cause noxious odours, amongst other things, by the time of the 2012 leak.
Yes, but her evidence was it was much worse after the 2012 leak.
My lady, yes, and the judge seems to have accepted that evidence.
So doesn't that show that this is not how it was dealt with at the trial, the evidence of this? It was dealt with by her evidence in the witness box, which the judge accepted, that that the water tasted vile and the fruit all withered on the tree, and she could smell this terrible smell the whole time.
Well, my lady, the water tasting vile and the fruit trees dying were all 1994.
Yes, yes.
But my lady, the heart of our complaint on the migration issue is that we'll come to it. But the appellant's expert witness, Mr. Ramirez, said Mr. Ramirez was involved in, as it were, all of the remediation activities, and he said there is no doubt in my mind, looking at the various samples that were taken and the various readings that were obtained from the analysis, that the 2012 leak had no impact on the plaintiff's property.
Yeah, and her evidence was, well, yes, it did because there was a terrible smell, which was much worse.
Well, my lady, if I can put it this way, she gave...
That's the judge had to decide between them, didn't he?
Well, she gave that sort of subjective evidence.
Yeah.
And no doubt that was evidence that would have to be taken into account. Our complaint is that the judge didn't even look at Mr. Ramirez's evidence or deal with it. And obviously, it's possible, for example, that at the time of the 2012 leak, the plaintiff would have been smelling smells of petrol because there's all this petrol sitting not too far away in the service station site. One imagines that there must have been temporarily smells drifting all over the place. But the point was that these samples were taken at the time, which showed to the scientists, as it were, no migration of property, of contaminants onto her property at the time. And we say that the judge simply couldn't properly make a finding that there had been contamination.
So he had to disbelieve her evidence?
Well, my lady, not necessarily, but he had to deal with the scientific evidence. And as we'll see, there wasn't even a contest of scientific evidence because the respondent's expert witness, presumably advisedly, didn't seek to say whether any contamination was caused in 1994 or 2012. Simply said, as it were, there has been some contamination. If I can then move to the passage of the report that dealt with impacted groundwater, which is 976 Roman 8. And the board sees under 3.3 there that the extent of contamination in groundwater was assessed during 3 sampling events in March 2013, May 2013, and October 2013. Figure 16, which we looked at a moment ago, shows the extent of benzene in the groundwater surrounding the site based on the combination of data from all sampling events. It shows the well locations. It goes on to give some more information and refers specifically in the bullet points to the various properties north of Robinson Road, north of the site. And then right at the foot of the page of 9768, a groundwater contaminant plume that appears to be separate from the contamination caused by the fuel dispenser release is located in the southeast corner of the Rubis property, near the CBL HEB. In October 2013, well MW52 contained a particular level of benzene, and says well MW28 is located closer to the former UST area. Now, as we'll see in a moment, the case advanced by the respondent in the trial was that this separate area of contamination was in fact the continuing manifestation of the 1994 leak. Now, just to make one final point from figure 16, so back to 97631. Again, if one's able to zoom in, the well MW47. So we know that this diagram contains the combined results of those analyses that have been referred to there. And
So sorry, which page is this?
sorry, my Lord, it's 97631.
Thank you.
What are we zooming into?
Zooming in on the LR, so the respondent's property,
Yep.
well MW47, which is the
Yeah.
monitoring well there, one sees the letters ND, which denotes not detected. So
Where do you see that?
Just very slightly underneath.
if my Lord sees the words residential area,
Yes, and I've got MV47.
Beneath that is an ND.
beneath that's
So that's
ND,
ND. I've got it. Yes, thank
that's
you.
not detected.
Very well on my page. Yep, got it.
And again, if one moves to the north part of the plant, one sees some NDs outside the 1 part per billion line. And it's hard because of the magnification, but
Okay.
the monitoring wells inside there actually have positive figures given, showing obviously that
So they've drawn the line so it's just inside the NDs. That is basically
exactly, my Lord, yes.
Yeah.
Can I then take it through, please, in the body of the report to 97613, so 976X triple I
97613.
13.
Yeah.
We're in a section of the report now called Stakeholder Interviews. That begins on the preceding page. And just over halfway down, one sees a bullet point. BVI also met with 4 residential property owners. Lillian Russell, the respondent, who's lived in her home east of the Rubis facility for over 35 years. And then some other people too.
And was the petrol station was going for the whole of those 35 years?
I believe so, my lady, yes.
So that's before the 1994 leak.
My lady, I would need to check whether there was any evidence as to when the site first started operating as a service station, but I think the evidence suggested it had been in operation for some time as a Texaco service station before the 1994 leak. Right at the foot of this page, it said that based on discussions with Ms. Russell and the holders, another release occurred at the facility approximately 20 years ago that resulted in contamination of their private wells. At that time, samples were collected from both wells and they were told their water was contaminated and they should use government water supply. Neither property's owner aware of any cleanup action initiated as a result of this spill that occurred in the early 1990s. And this is just over the page, reference to the respondent's fruit trees and concerns about cancer in relation to local residents. And then if I can take it through, please, to the conclusions section. And picking it up is 97620, 976XX, where we see the recommendations starting right at the foot of the page. And going across to the following page, the 4th bullet point down, so now on 97621. The isolated groundwater contamination at the southeast corner of the Rubis property that's likely the result of a historic release should be completely defined and measures implemented to reduce groundwater concentrations to FDEP, I think that's an American body, groundwater target cleanup levels. Just pausing there, because this chimes with something that we'll see Mr. Bowleg said. This report contemplates that the contamination, which originated in the 1990s in that area of the underground storage tanks, appears might well have persisted even to the time of this report.
But how is that consistent with the not detected?
Well, my lady, this is referring to contamination found in the area of the storage tanks on the service station site. So this is not referring to MW47. This is at the southeast corner of the Rubis property, so of the service station site. And for completeness, 3 bullet points up, one sees in this recommendation section, it is said, the potential for the migration of site-related contamination through soil gas to the residential buildings east of the Rubis property.
Sorry, where?
My lord, that's the 3rd bullet point up from the bottom on 97621. It's curious because it doesn't actually tell us, it seems to be incomplete in this recommendation section. It simply says, the potential for the migration of site-related contamination through soil gas to the residential buildings east of the Rubis property.
I don't think you've told us at the moment how this report was deployed at the trial.
My lord, it was simply in evidence by agreement. So both sides...
Not agreed, its content wasn't agreed, presumably.
Well, my lord...
It was allowed to be in evidence.
Certainly both sides relied on it.
Was its maker called?
No. And I'm not sure, actually, we know which individual authored the report.
It was allowed in as a document by both sides.
Yes.
Maker not identified or called.
No. And my lord, I'll show you, but it certainly seems to, by agreement, to have been treated as evidence of the accuracy of its contents. In particular, the respondent relied on it, these references to the contamination in the area of the underground storage tanks, which appeared to be traceable back to the 1994 leak.
We don't seem to be progressing terribly fast.
Well, my lord, I know, but it's obviously important for my migration issue submissions that one...
I mean, you know how long we've got.
My lord, I do. I'm going to take the rest of it very briefly, if I may, in relation to the evidential points. Mr. Bowleg was the respondent's relevant expert witness, and his relevant report starts at page 978. At page 979, he explains in the top paragraph what he did, that in August 2014 he took a sample from MW47 and had it analysed. And page 980 shows what came back from the lab following that analysis. So one sees not detected for benzene, not detected for something called MTBE, but then some positive figures in micrograms per litre for those substances there referred to.
What in the 3598 with the non-D? Oh, so it's not. Whichever one. What was that not detecting? That was just benzene.
Benzene, yes.
So it didn't test for these other things which he found in the sample.
Certainly 3598 refers only to benzene. then taking it through to page 981, the words in bold and italicized in the middle of the page. The suspected source of the contamination is the fuel facility at the intersection of Robinson Road and Old Trail Road. The typical flow of groundwater in the area is towards the north or northeast, with minor variations. To date, we continue to detect traces of BTEX towards the east of the suspected site. This is also following extensive remediation activities at the suspected source site.
So BTEX is benzene, toluene, ethyl benzene and xylene.
I think that's right, my lady, yes. And taking it through to the final page, page 985. Conclusions and recommendations. We recommend the following. Second bullet point, the suspected source of the contamination is the Rubis Texaco fuel facility at the intersection of Robinson Road and Old Trail Road. The source of the fuel spill must be isolated. The contamination has migrated from the source site.
Why in the Black and Veatch report do they only report the benzene result?
My lady, again, we don't have an answer from the events at trial.
But your point is that Mr. Bowleg doesn't say whether this is migration that's left over from 1994 or whether there's been, he doesn't suggest there's been any more since, in positive terms anyway.
My Lord, precisely. And a subsidiary point, he gives no reasoning for his conclusion that the suspected source of what he found is the service station site. Now, you might think, well,
One might think it was blinding news.
isn't it obvious? My Lord, yes. Except that when we look at
24,000 gallons of oil seep into the ground.
I won't try and show you the detail, but the readings that he found were magnitudes, orders of magnitude lower than the readings found, for example, in the properties north of the site. Mr. Ramirez said, and I will show you this, in his evidence.
Well, if you look at 984, you can see the comparison between 47 and 45 and 46.
My Lord, indeed. I'm grateful. The table at 984. So at 45 and 46 are on the north side of the site.
At the bottom of the page.
And you can see the sort of disparity there. And now what Mr. Ramirez said was, well, looking at that amongst other things, the tiny levels found when MW47 was sampled by Mr. Bowleg could have come from someone spilling a bit of petrol when using a lawnmower, or someone doing things like cleaning paintbrushes in their garden. And again, that's evidence that the judge simply didn't grapple with, nor did the Court of Appeal.
Well, you'll come to it in due course, but we'll need to see it shown whether the Court of Appeal was taken through this. Or doesn't see it in the general argument.
My Lord, we'll give you those references.
So you're saying that the sample results on 984 for the well, you're saying that, is those for soil or water?
Water.
That's water, my lady. So that's taken from the well.
Right, and the well is 9.6 feet deep, or the well is, how low is the sample? The well depth is 15.25 feet, and the depth to the water.
They're all quite similar, I think, these wells, but...
Yes, but I'm just thinking the likelihood of it coming from somebody spilling a bit of petrol in a lawnmower, from the lawnmower, to get down to 15 feet in a well.
Well, my lady, I might not show you, but I'll give you the references. Mr. Ramirez wasn't tested in cross-examination when he said that. The way it was handled at trial on behalf of the respondent was that once it became clear that Mr. Ramirez was speaking only to the 2012 leak, as it were, his evidence was left unchallenged. So, in short, the way the respondent, I think, tactically approached the trial was, well, if I succeed in relation to some contamination, it must have come from either the 1994 leak or the 2012 leak. Rubis would be liable in either case, so I don't need to show which. Of course, given that the claim against Rubis in relation to the 1994 leak has failed, then that the dichotomy between the two becomes all important. Now,
although limitation and non-inheritance were both points taken in the defence.
Indeed, my Lord, yes. Yes.
By non-inheritance, I mean non-inheritance by Rubis from Texaco.
Of Texaco's, any liability attaching to Texaco, yes. Can I briefly show you Mr. Ramirez's relevant expert witness statement? It starts at page 283. Page 285, paragraph 8, he makes it clear that he's not able to say anything about whether there was any contamination which took place in 1994, but he is able to comment on the 2012 leak and the current state of the plaintiff's property in terms of contamination. So everything he says refers to 2012. Mr. Ramirez, I should say, he explains works for a firm called Arcadis, which was contracted by Rubis to come in and do the extensive investigation and remediation activities once the 2012 leak was discovered. At paragraph 12, he says that as part of the remediation process, we produced maps over time defining the impacted zone and setting out areas of concentration, which clearly show the limited scope of the impacted zone and the properties which actually have been impacted. I don't propose to take the board to those. They're all similar to the document we've been looking at figure 16. But for your note, they're at 292, 289 and 291.
Sorry, could you give me those?
My Lord, yes. 292,
Yes.
the first in time, 289,
Yes.
second in time, and 291
Thank you.
is the third in time. Then at paragraph 13, he says, to further assist with the remediation process, monitoring wells were placed on various properties. And in the case of the plaintiff's property, the relevant well was given identifier MW47, samples systematically and regularly taken, which he exhibits. And the page that shows MW47 that he's referring to is 1059. And just briefly to show you that, 1059, MW47 is right at the top of the page. And we see the figures that he's referring to there, 3 different dates and a number of NDs, but in relation to ethyl benzene and xylene, some positive figures which generally, again, are orders of magnitude lower than the positive figures shown for the other wells. Sometimes flagged with a J, and he said in cross-examination that the J flag tends to suggest that there's something suspect about the figure, some reason for being doubtful about it. There is an annotation on page 1060, a little key that explains the J. See, it says approximate value. Result is less than reportable limit, greater than or equal to method detection limit. But then, having given that information, he says at paragraph 15, page 286.
Okay, sorry, just can I check? MW is a monitoring well. Is RW, is that a residential well? Is that the difference between the two? You happen to know? If you don't know, don't worry.
My Lord, we'll check.
It's plausible.
That sounds logical, but I can't give you an immediate answer.
Okay, don't worry.
We've read paragraph 15.
So paragraph 15, obviously a clear opinion expressed there based upon his review of that data, and paragraph 20, similar.
But why is that any less of a bold statement than what you can claim Mr. Bowleg said?
Well, my lady, paragraph 15 in particular, he says, having consistently reviewed the relevant maps and the data from the monitoring wells. So
But Mr. Bowleg looked at his data that you've shown us.
My lady, he did, although for what it's worth, he doesn't say, as it were, having reviewed the data, he says.
Well, he doesn't express a contrary opinion, is your point, I think.
My lord, absolutely. Now, we've referred to it in our case. I don't think I need to turn it up, but it's also relevant to note that in his pretty extensive evidence in chief, Mr. Bowleg said, and the reference is at page 354, lines 5 to 27, he said that he was asked, as relates to contaminants in the absence of remediation, what, if anything, happens to those contaminants? And he said, in the absence of remediation, the contaminants will remain in the groundwater and soil until such time as they're remediated fully or many, many years later. So again, this comes back to our point that the way the case was advanced to trial was that the 1994 contamination was still present as at the time of the 2012 leak. Now, I've told the board that Mr. Ramirez evidence wasn't materially challenged in cross-examination. In the interest of time, I won't try and show you that. The key...
He was cross-examined, presumably.
When cross-examined...
You say there wasn't a challenge to this finding? Or this
once it became clear that he was speaking about the 2012 leak only, he wasn't challenged. So he wasn't challenged on his assertion or his evidence that these levels are so low that they could have come from ordinary domestic activities. For your note, that's at page 420, lines 17 to 24. And then pages 428 through to 434, in relation to paragraphs 15 and 20 of his report, once my learned friend elicited from him that very clearly that he was speaking about the 2012 leak only, his evidence was left at that.
Which were the lines on 428? Sorry.
My lord. So page 428, line 21, Ms. Roll took him to paragraph 15 of his witness statement.
Yeah.
And then she made the point over on 429 that she wasn't waiving any Brown and Dunn point by asking questions about this. And then line 14 on page 429, she says, am I correct, that conclusion is based on the maps you generated? And he said it's based on data that we've collected throughout this investigation remediation process. And am I correct in saying it's data you refer to from the monitoring wells that you dug? And he says, correct. And then page 430, top of the page, it says, correct, I'm referring to the 2012. Yes, that's all I'm referring to because you did state in your witness statement quite clearly that that's what your evidence relates to. And then, taking it through, my lord, to page 434, line 17, he's asked about paragraph 20 of his report. Says this is in relation because of the 2012 release. Yes, I maintain there's no impact from the 2012 release to that property. And Ms. Roll said, well, that's a different statement. We dealt with that already. Here you're saying there's absolutely no contamination in groundwater on the property. Isn't that inconsistent with the test? No, because I believe I stated at the beginning of my statement that I was referring to the 2012 remediation or release. I don't have any evidence for me to say that these are connected. And it's then said to him, top of page 435, okay, so that's what you mean by paragraph 20. Yes. Okay, so I won't press you any further, because paragraph 20, as I read it, means something else. But I'll go on the basis that that's what you mean by that statement. And once it was elicited that he was, in paragraph 20, he was saying there's no contamination from the 2012 leak, his evidence was left at that. Now, can I move then to my submissions on the migration issue? And to a large extent, I've now foreshadowed these.
Sorry, just on his paragraph 20.
Yes.
I mean, I'm a little bit confused as to how he could say there was no contamination at all from the 2012-2013 leak, when at the same time he's accepting there is some contamination.
Well, my lord, what I didn't show you in the interest of time was when he was asked about the levels found in, I think, both his sampling exercises and Mr. Bowleg's, he said those levels are so low, they could have come from ordinary domestic activities, use of a lawnmower.
That's page 420, is it?
Yeah, so that's why she's challenging him on it, because she thought he was saying there was no contamination in the soil, and he says, yes, that's not what I'm saying. There is contamination in the soil, but
yes,
he can't say whether it comes from 1994 or 2012.
Well, I think he went further and he said, I can say that in my opinion, there is no contamination from the 2012 leak on the property. So,
how can he possibly say that?
I mean,
well,
we've seen the results of MW47, that there is something in the soil which is not naturally occurring in the Bahamas.
Yes.
There is some contamination.
My lord, indeed.
But he said in paragraph 20 there was none at all.
I think he says, looking at the data that was gathered, the movements of the groundwater plumes, and so on, and looking at the levels of contaminants in MW47 versus the levels in other wells, that in his opinion, whatever was found in MW47 after the 2012 leak was not contamination that came from that leak.
Right, okay, thank you.
So is he using the word contamination then in a different way? She thought he was saying that there was no petroleum found. But she's using the word contamination as being contamination from the petrol station.
Well, I'm not sure. I think once it became clear from his answers that when he said in paragraphs 15 and 20 in his report, there's no contamination. Once it became clear he was saying there's no contamination coming from the 2012 leak, then at that point, his evidence was left. It was left to that, as we saw. Because she said, Ms. Roll said at that point, well, then I've got no further questions.
Right, but sorry, I'm just looking at the cross-examination on page 420. He does accept that there was contamination at some time. Yeah.
My lord, yes, and I believe it's there that he says the levels were so low they could have come from use of a lawnmower or cleaning paintbrushes.
And that could have got into the water in the well.
That's what he said, my lady, yes.
Well, there's three possibilities, presumably. Either it came from the lawnmower, it came from the 1994 leak, or it came from the later leak.
Yes.
Okay.
That must be right. Now, just looking then at how the trial judge dealt with this or didn't deal with it. What happened, as the board's seen from our written case, is that Ms. Roll put in some supplemental closing submissions, which were based on the rule in Brown and Dunn, saying that essentially, because Mr. Bowleg, in relation to this issue, saying that because Mr. Bowleg had not been asked questions about whether the 2012 leak caused contamination, that the judge was constrained to proceed on the basis that that had been conceded or something to that effect, and that therefore that must be taken as read. The board will have seen the way the judgment is structured. It contains lots of long citations and quotations from other documents. Picking it up at the relevant passage that the judge cited in relation to Brown and Dunn, so he's quoting now from the supplemental closing submissions. We can pick it up at page 173. The 173 is where the judge begins to set out in extenso the written submissions on the rule in Brown and Dunn. So he begins to do that at paragraph 98.
Sorry.
Oh, I see. So this pagination is...
Yeah, so 98 is a paragraph of the judgment itself.
Right, 173, did you say?
Sorry, my lord, page 170, sorry.
Ah, right. Yeah, we get 98 is his paragraphs.
Yes.
And 20 and following are all a quotation from
All
the
quotations.
respondent submission.
Yes. And so staying for a moment within the quoted section, taking it through to page 173.
So he's not, at this stage, is he expressing any view about whether they're right or not?
No. At this stage, he's simply setting out the...
Simply quoting them.
Yes.
But he does ultimately accept them as far as one can tell.
He does indeed. But what I wanted to show the board was, as it were, the particular parts of the argument that he accepted that went to this issue. So you can see how, in a sort of shorthand way, he constructed his judgment. So page 173, right at the foot of the page, quoting from the written argument. The plaintiff's assertion that the source of the contamination was the service station and that her property was impacted by the 2012 leak. Then the board sees paragraphs 44 through to 50 of the written argument there. And in particular, for example, paragraph 50, while it's noted that the defendant's pleaded case was there was no contamination from the 2012 leak, and that this was a statement made by Mr. Ramirez, the reality is that the plaintiff's expert witness was in the box, and the critical element of the defendant's case, that being that the 2012 leak did not impact the plaintiff's property, was never put to him, so as to allow him to further elaborate on that important proposition of fact beyond what he'd said in his evidence in chief. And I'll come back to it, but it's our submission that's the wrong approach, and that under the rule in Brown and Dunn, in relation to this sort of context, what you may have to do is to traverse something that an expert has said. You don't need to take them to a topic that they haven't addressed and give them an opportunity to make good what's otherwise a deficit in their report. And then the quotations stop at page 196, paragraph 99. So this is where, paragraph 99 is where we move back to the judge's judgment. The very final paragraph that he'd quoted was 112 of the argument, where it had been argued Mr. Ramirez's suggestion that the property wasn't impacted by the 2012 leak is one that the defendant is no longer able to make, given this proposition wasn't specifically put to Mr. Bowleg. Paragraph 99, the judge records that counsel had meticulously set out the above. It then moves into some long citations from Brown and Dunn. And then turning to page 202, paragraphs 105, 106, where the judge, in a sort of omnibus way, says, I accept everything that has been said in the argument that I've quoted. And each and every failure to cross-examine as set out by the plaintiff above is accepted as evidence which goes to the plaintiff's credit. Not that language might suggest something else, but he appears to have taken, to have accepted the argument that, amongst other things, it was now, he was constrained to accept that there had been contamination as a result of the 2012 leak on the footing of the argument that had been made to him. Now, we submit that that was wrong for three reasons. Firstly, Mr. Bowleg simply had not given evidence in his report or in his oral evidence in chief that, in his opinion, the contaminants that he found, or that anyone had found, had resulted, whether in whole or in part, from the 2012 leak.
So there was nothing that needed to be challenged?
Nothing that needed to be challenged. Secondly, his evidence that the suspected source of the substances that he found was the service station was unreasoned. It was a bare ipse dixit, and so for that further reason, that part of his evidence did not need to be traversed in cross-examination.
Sorry, what was the ipse dixit contamination?
That the suspected source of the contamination is the service station. There was no reasoning given for that at all.
That's the bit that's blindingly obvious. Well, apart from the lawn mowers and the paintbrushes.
My lord, yes. Which, in this case, given the disparity between the tiny levels of contaminants found in MW7 and those found in wells to the north of the site, which I should say Mr. Bowleg didn't comment anywhere on that disparity, didn't address it at all. But in particular, given Mr. Ramirez's evidence that those sorts of levels are perfectly consistent with usual domestic activities, it is a relevant ipse dixit, bare ipse dixit. Now, I've covered the first of those reasons, I think, in my submissions already. As to the second of those reasons, we've set out the key propositions to be derived from Tuohy and Griffiths at paragraph 24 of our case, at page 3611. If I can take the references for the sake of efficiency in that way. Tuohy, as the board will be aware, is now the leading authority on...
What page are we at?
My lady, 3611. Paragraph 24. We set out what we say are the key propositions to be derived from Tuohy. Firstly, that what really matters in most cases is the reasons given for the opinion, and that a bold statement of opinion is unlikely to assist the court unless it can be taken to have been admitted. And secondly, same point really, a bare ipse dixit doesn't just carry little weight, it's worthless. Thirdly, there are circumstances in which the rule in Brown and Dunn will generally not apply, and which include cases where one's dealing with a bare ipse dixit, and of course I should say...
Is that a bold assertion, or should it be a bald assertion?
I think it should be bold.
Might be quite bold, but probably bald.
Probably both, yes, my lord, yes. And of course, one might say it's too obvious to require saying that it also doesn't apply where the relevant expert hasn't actually given any relevant evidence on a point, then there's nothing to be traversed.
Can I just take you back? I mean, your main point seems to be that Mr. Bowleg didn't distinguish as to the time when this contamination occurred. Whether was it 1994 or was it 2012?
Yes.
That didn't matter from the point of view of the plaintiff's case, but it did critically matter, didn't it, from the point of view of the defendant's case for two reasons: non-inheritance of Texaco's liabilities and limitation. So what does that reflect in terms of one's cross-examination obligation? Are you entitled to say, well, the expert didn't distinguish, so the court can ignore any possibility it came from two? Or are you meant to cross-examine to establish and to put your case that if there was any, it only came from the earlier period?
My Lord, in my submission, you're entitled to not to cross-examine the expert. What that will mean is that you can't then say, leaving aside the bald ipse dixit point, you can't then say...
I'm leaving that aside.
Yes. You can't then say his opinion doesn't vouch a contention that there was contamination that came from the site. What you would say in closing is, yes, he said some contamination came from the site, but...
He didn't say anything to indicate it came from 2012.
Yes.
It's equally consistent with it having been left from the previous.
Yes. And it was very much, for the moment I've not taken the board to the references. I may do in my reply, but it was very much the case advanced, seemingly at trial, by Melody Friend, that the 1994 leak was a real contender because of these references in the Black and Veatch report to the historic release, and that being right next door to the respondent's property. So, my Lord, obviously in these sorts of cases an advocate has to make some tactical decisions, but we do submit that where the expert has left that question unaddressed, you're perfectly entitled not to cross-examine, and colloquially you'd say, well, I'm going to bank the fact that the expert hasn't... I think I'm going to be okay in relation to the 1994 leak because of limitation and because the claim is misconceived. I don't want to give the expert the opportunity to say, oh, well, I think there was some contamination from the 2012 leak, so I'm not even going to go there. And you're certainly entitled to take that approach. That may open you to some risk in relation to the 1994 leak if you're wrong and your limitation points and so on aren't good. But you're perfectly entitled to say, well, I'm not going to give the expert the opportunity to make good what, if I'm right, is a deficit in his report. Our third point, which we make in our case at paragraph 25, 3611, I won't seek to develop it orally further, is that even if one got this far, in any event, under the rule in Brown and Dunn, the court still has to evaluate the evidence that the court hears, and particularly in relation to expert evidence, it doesn't simply say, oh, well, I have to accept everything that this particular expert said. But we don't really need to go that far, we say, because of the logically prior points. Can I look then at how the Court of Appeal dealt with this? I'm picking up the Court of Appeal judgment at page 14.
Are you going to deal with the grounds of appeal?
My Lord, I'm coming to that now, yes.
Okay, fine.
Yes. So at page 1481, paragraph 24, the Court of Appeal set out in extenso Rubis's grounds of appeal. Omitting some introductory words from paragraph 1, but for present purposes I don't think that matters. So if we can take it through to 1482, what was ground 1C, top of the page.
Failure to find.
the learned judge failed to find as an issue of fact whether the release of petroleum products from the service station in or about 2012 migrated onto or escaped to the respondent's property at all. And then ground 5 on page 1482 is a sort of omnibus complaint, but one which is relevant here, we say, given the significant defects with the first instance judgment.
Is there anywhere in the grounds of appeal where 5 and the following grounds are sort of tied into anything in particular? They just seem to be sort of general statements of objection to the judge's process lifted out of a precedent book without being keyed down.
Well, 6 and 8 are key here. The 6 and 8 complain that the judge didn't grapple with the expert evidence advanced on behalf of the Rubis. And we'll see in a moment if we have to, but it was quite clear that that was referring to Mr. Ramirez's evidence about the 2012 leak having caused no contamination. And that's how learned friend understood it. We see that from the transcript. Now, turning through to page 1494, paragraph 48, in the preceding section of the judgment, the Court of Appeal had dealt with the 1994 leak. I don't propose to go to that.
Sorry,
1494. Paragraph 48. One can see here one aspect of what seems to have gone wrong. The Court of Appeal says here, with respect to this leak, Rubis complains that, and sets out, firstly, ground 1C, then secondly, 2 of the Rylands and Fletcher grounds. But the Court of Appeal seems simply to have overlooked the grounds 5, 6 and 8. In particular 6 and 8, which complained about the judge's approach in relation to Brown and Dunn and failing to deal with the expert evidence. Now, those grounds had been fully argued before the Court of Appeal. For the moment, just to give you the notes, in relation to Rubis's skeleton argument, pages 2214 to 2224, and in relation to the transcript of the hearing before the Court of Appeal, one sees it at pages 1781, 1798.
What, all the way through to 98?
No, I think on these pages, as where the argument jumps around a bit. 1800, 1802, and 2090 to 2091. But 2090, my lady. To
90 to 91.
2091, yes, 90 to 91. But one sees it. One sees from paragraph 48 of the Court of Appeal judgment itself that it simply overlooks the grounds 5, 6, and 8. Looking at what it did do, paragraph 50 on page 1494, it said the judge clearly found as a fact that there was a 2012-2013 release, and refers to paragraph 146 of the first instance judgment, and goes on to say that it was an agreed fact that Rubis bought the gas station in 2012 and that in or about 2012 there was a leak.
Which paragraph was that?
My lord, that's paragraph 50.
50, yes, thank you.
Page 1494. And it then moved on to the correct defendant point. i.e. whether under Rylands and Fletcher principles, and no doubt more widely, but importantly in relation to Rylands and Fletcher, whether Fiorente was the correct defendant or whether Rubis was the correct defendant. So, in short, the Court of Appeal simply, as it were, the judge having failed, we say, to deal with the important expert evidence, the Court of Appeal then overlooked the relevant grounds complaining about that and simply omitted to deal with those grounds of appeal. Now, so far as
the skeleton argument, I think it's quite important to your, you don't have time to take it to us, but your skeleton argument did over several pages, as I read it, argue that the reliance on Brown and Dunn was misplaced.
My Lord, absolutely, yes. And indeed, one sees from the transcript, I think the final references I gave the board in particular, 2090 and 2091, Mr. Hanna said, in relation to the Brown and Dunn argument, look, amongst other things, Mr. Bowleg simply didn't deal with, didn't say in his evidence that there was contamination from the 2012 leak in his opinion. So Mr. Hanna said in completely clear terms that the Brown and Dunn point was false in relation to this migration issue.
And everyone ignored Miss Russell's evidence.
Well, my lady, it's not so much a question of ignoring it. It's more a question of dealing with the issue whilst dealing with all of the relevant evidence. So
I'm not sure she gave any evidence about 2012 specifically. I thought the fruit trees was all about 1994.
The fruit trees was earlier, but the odour was...
The fruit trees was earlier. I think in one paragraph of her witness statement, she said the smells became worse around the time of the 2012.
I see.
Didn't say, as well, how long that state of affairs
And was
carried on.
that put to her that wasn't true?
My lady, it wasn't, no.
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 Good. What's the page reference for that, please?
For the witness statement, my lord, it is... Forgive me. Our witness statement begins at page 255, and the relevant paragraph that we're talking about here is paragraph 74 on page 267.
Thank you very much.
It said, after the 2012-2013 leak, there was an appreciable difference in the level of fumes in the home. The odour was stronger and much more consistent and persistent.
267.
Page 267.
Thanks.
And it was not put to her that was untrue.
My lady, it wasn't.
You would say they have nothing to do with migration. But there's one's got a huge spillage not that far away.
Yeah.
It may well mean that in any event there's going to be an
My lord, entirely. To a layman, it wouldn't seem surprising where you've got 24,000 gallons of petrol spilled right next door for a period.
But it's underground, we've asked.
My lady, yes.
And it's not just the general level of fumes in the vicinity, it's the fumes in the home.
She was plainly talking about the fumes that, as it were, she
Inside
smelled.
her house, not
In,
just
whilst,
by being somewhere near a petrol station where there's a leak going.
no.
Well, we don't have to infer what the level of chemicals was in the groundwater in the home because we've got the data for it.
Yes,
Whether it caused the smell or not is another matter.
my lord, exactly. Now, just to deal, I may have to come back to this in reply, but just to deal with the argument that so far as these grounds are concerned, that the argument that we put to the board is new and wasn't raised in the Court of Appeal. In my submission, that's entirely wrong when you look in particular at grounds 5, 6 and 8, Court of Appeal grounds 5, 6 and 8. And in terms of proper approach to the interpretation, if you like, of grounds of appeal, we submit that as a matter of general principle, in considering what a ground of appeal means, the court is really looking at what a reasonable person with relevant knowledge would understand it to mean. Relevant knowledge includes knowledge of the issues at trial and of the content of any skeleton argument accompanying the grounds, and the documents should be read together. Grounds of appeal should also be read together with each other. It often happens that, as the board will well know, that, as it were, depending on drafting styles, one ground goes alongside another, and it goes alongside another, and they get taken together, but as it were, the meaning of one informs the other. And we submit that interpretations that lead to absurd results should be avoided. So, on appropriate facts, reductive or very restrictive, strict literal interpretations are to be avoided if they lead to absurd results, and if the true intended meaning is clear from the ground read in its content. So taking, for example, ground 1C here as an example, we submit that what ground 1C was plainly complaining about was that the judge had erred in not dealing with the migration issue, not making a finding. The approach he took was that it wasn't open to him to consider the evidence and make findings. But we submit its implicit in that, particularly when it's read alongside grounds 5, 6 and 8, that the appellant was contending that, as were, had a finding been made, it would have been in the appellant's favour. You don't say, well, I accept that had the judge actually bothered to make a finding, the finding would have been against me, but my complaint is the judge didn't make a finding.
The argument was that he didn't engage at all with the facts because he thought as a matter of law the plaintiff was entitled to win because her expert had said something which hadn't been challenged, and that was, as a matter of law, the end of the point.
It was taken to be conceded, yes. And just for the board's note, I said earlier that the transcript of the Court of Appeal makes it clear that that's how grounds 6 and 8 were understood by the respondent. And those references are at pages 1954 to 1956. At 1954, Ms. Roll said, so essentially, my lords, with grounds of appeal 6 and 8, the gravamen of the complaint is that the learned judge failed to consider conflicting evidence, meaning evidence that was adduced by the respondent on expert issues, expert testimony vis-a-vis that was adduced by the appellant, and to, I guess, reconcile to and demonstrate why it is he preferred the respondent's evidence to that of the appellant. And at 1956, she said, so when you read in these grounds of appeal number 6 and 8, this whole issue of conflict, the only conflict there was whether or not the 2012 spill impacted the respondent's property. And that's the conflict that the appellant is, by reason of grounds of appeal 6 and 8, complaining the judge didn't properly analyse. Now, I'm conscious of the time, and that I've dealt with the migration issue. I think in the circumstances,
issue 2 at all.
My lord, I haven't.
And we're now at 12:30.
We're now at 2 hours, indeed. I think I've also essentially, in my prefatory comments and as I've been going along, made my points on the fourth issue, namely the fact that the Court of Appeal simply wasn't in a position to do what it did and to say, oh, well, we are able to say that the diminution in value is all attributable to the 2012 leak. Obviously, that's partly dependent on, if I'm right about the migration issue, then obviously that falls away. If I'm wrong about the migration issue, then in any event, on the evidence that was before the Court of Appeal, it simply wasn't able to say that the diminution in value testified to by the claimant's expert witness on valuation was, the Court of Appeal was able to say, oh, this must all be down to the 2012 leak.
Well, what was it that led to the diminution in value?
Well, my lady, what the expert said, that the value of the property, absent any contamination, would be $225,000, and that the value of the property in a contaminated state was $131,000 lower than that.
But if it's doesn't matter, even if there'd been no contamination in 1994, if it is now contaminated by the 2012 leak, then that would be the diminution in value of contaminated land, even if there'd been nothing wrong with it at all before 2012. So why does it matter that it was previously contaminated? Suppose it had been entirely remediated after 1994.
Yes.
And yet now it's contaminated, and that's led to the drop in value.
Ah, well, my lady, that would be different, because then you would say it's a matter of, as it were, causation, looking at things in 2012 and thereafter. The diminution in value can all be attributed to the 2012 leak.
Well, isn't that what they said?
No, he simply said, uncontaminated, it's $225,000. Contaminated, it's $131,000 lower. So if, as the judge accepted, the property was already in a contaminated state at the time of the 2012 leak, then the 2012 leak didn't cause any further damage. It's Baker and Willoughby and Performance Cars and Abraham. But if my car is already scratched on the bonnet, which was roughly Performance Cars and Abraham, and then someone else comes along and scratches it again.
Yeah, but this isn't somebody else. Well, I suppose it is, because it's Texaco.
Yes. Yes.
But if the bonnet's scratched and then the car's written off in the next crash, don't you get the value of the car?
My lady, you do. You get the value of the car in its damaged state. Where it can't be said that the supervening event has caused further diminution in value, then the second tortfeasor is able to say, well, I take my plaintiff as I find him, and the relevant property was already in a damaged state, and my tort has not increased or hasn't identifiably increased the extent of the damage.
Assuming that's right as a matter of principle, didn't the Court of Appeal in any event say that it was more likely than not that it was attributable to the 2012 leak?
My lord, they did.
But your argument is much the same as you've already been making, that they weren't entitled to come to that finding.
They weren't entitled to come to that finding.
The judge didn't.
And the judge didn't. And not only that, but the judge's findings must have entailed accepting that the 1994 leak had contaminated the property and that the property remained contaminated as a result of the 1994 leak as at 2012. Hence, the judge giving damages based on loss of amenity, for example, right through the relevant period down to trial. And accepting as were the underlying factual premise of the case, that there had been a culpable omission to remediate, which continued. So the reason the judge said the claim's not time-barred is the judge said, well, the duty to remediate is continuing. There's been a continuing breach of it.
But had there been a proper... if it was more likely than not, if that was a correct finding, then there's no problem about the damages, as far as you're concerned.
If the evidence had been that any contamination due to the 1994 leak, given the passage of time,
has been ruled out.
on the balance of probabilities would have evaporated by the time of the 2012 leak, then it would be different. But of course, one saw that the Black and Veatch report, speaking about the isolated contamination in the southeastern corner, contemplated that that contamination would still be present and needed to be addressed. So that tended to go against that suggestion. And of course, Mr. Bowleg has said in evidence in chief that if not removed by remediation, contaminants will remain for many, many years.
Well, Mr. Casey, you're living on what I would call reply time.
My lord, yes.
So you can either leave everything else to your written submission by then, or you can gobble up more of your reply.
My lord, if I may, I'll do the former. I don't abandon anything, but as it were, I've ploughed my furrow, but I think I've ploughed it for as long as I'm entitled to.
Yes. Thank you. Ms. Raleigh. Is it Miss Raleigh or Mrs. Raleigh? Mrs. Raleigh. I thought it was. Forgive me.
Respondent's written case is 3647.
2647.
3647.
3647.
And there is a supplement to that that was emailed on the 10th of October 2025 as per the board's request. I think if we would go to the respondent's written case, specifically to paragraph 14, that's on page 3654. The reason for that is just to give a summary before I get into great detail. A summary of what the respondent's response has been to this appeal. It's set out at paragraph 14, that is on page 3654. Paragraph 14 says,